I'm a senior staff attorney at Legal Aid at Work, and I'm here with my colleague, Sayla. Do you want to introduce yourself?
Hi, everyone. Thanks so much for being patient. I'm Sayla Steiger, excited to be here with you today.
Thanks, Sayla. And so we'll be covering rights to paid time off and accommodations for people who are pregnant, new parents, and family caregivers, focusing on the rights of people who are workers in California, and being sure to highlight how the law has changed in the last year, because fortunately there have been some improvements over the last year. So a little bit about our organization. We are attorneys with Legal Aid at Work, which is a nonprofit that is focused on the workers' rights of communities that have been historically marginalized and people who face barriers in being able to access well-being and financial stability for themselves and their family through work. So as a part of that, we do trainings like this, and we create lots of educational materials that people can look at to learn about their rights when specific circumstances come up. We also advocate to have better laws and policies. One of the things that you'll realize throughout this is that our laws are not perfect, but every year we work hard to try to make sure that the laws are a little bit better so that more people are covered. And then beyond that, we have a free helpline. We have those for just general workers' rights questions, and then for our team specifically, where we focus on the rights of workers to be able to take care of themselves and their family without having to sacrifice their health, their job, or their income. We have a work and family helpline where we get over 1,000 calls per year from families and from healthcare providers and community health advocates who are trying to figure out how they can take advantage of paid leave, get time off when necessary for health or baby bonding, and keep their job. And in doing that, we provide one-on-one legal advice and can provide support when things go wrong, and can also represent folks sometimes and contact employers on their behalf, all the way through litigation, depending on the circumstance. So those are kind of the basics of what Legal Aid at Work does. And yeah, that's what we do. So just to preview the new rights from 2023 that we'll be discussing, there was a law that went through that will increase the amount of money that people are able to get on when they're taking leave for themselves or their family through paid family leave and state disability insurance, which will go into effect in 2025. There's a new bereavement leave law that allows people to take time off when a family member passes away. There's a law that expands the number of people that you can take time off to care for, to include, for the first time in the state, chosen family. San Francisco also passed a law that is first in the nation to allow parents and family caregivers to be able to get changes at work that they need so that they can care for their families and continue doing their jobs. And then other recent protections that have gone into place in California that not all employers or workers might know about, including a pretty significant expansion in lactation accommodation rights. And then also a law that expanded significantly the number of workers who are able to take job protected time off. So finally, digging into the substance, there's kind of 4 main categories of rights that we'll be talking about. So one is the right to take time off and to know that your job will be safe. A separate one is the right to get paid while you are taking time off from work. Folks also have the right not to face discrimination based on their pregnancy. And then folks who are pregnant or breastfeeding also have the right to workplace accommodations so that they can protect their health while continuing to work. So starting with pregnancy discrimination, Employers in California are not allowed to treat people worse because of the fact that they're pregnant, and that applies to hiring, firing, pay and benefits, and also promotions and demotions. And one of the things that we see come up most frequently is employers who are who try to force people onto leave and say like, oh, you're pregnant, you need to go onto leave. But if somebody wants to keep working and they can keep doing their job, that's not something that an employer is permitted to do. And they're also not allowed to create a hostile work environment. So to say negative things about pregnancy and to make it difficult for somebody to work through their conduct. Another important protection that we have in California is the right to pregnancy accommodations. So what that is changes at work that somebody needs because of their health in connection with pregnancy, childbirth, or a related health condition. In order to get a change at work for one of these reasons, somebody needs to ask their employer for that change. And this applies to anybody who has an employer with at least 5 employees. So somebody could be brand new in their job, they could work only a couple of hours per week. But if they have an employer with at least 5 employees, they are entitled to reasonable accommodations to allow them to continue working with their health condition. One thing to consider, though, is that the accommodation must be advised by a healthcare provider. So an employer is allowed to request a note from a healthcare provider saying that somebody needs this accommodation. So as far as what that means, we always want to offer advice that in asking for accommodations, it can be very helpful to be specific and to make smaller requests to start, because an employer absolutely has to provide an accommodation unless the change would be something so big that somebody would not be able to perform their job at all. So it can be helpful to include what that worker is capable of doing. If the issue is that they can't bend to, open the oven for the pizzas, it could be that someone needs to assist them with that, but they're still able to make pizzas, they're still able to do other things, they're still able to work the cash register, but to be specific and to include what they can do. For example, we have a suggestion for someone who's working security. So even if somebody requires a stool to sit, making it clear that they only require a stool to sit during the times that they're stationary, that they're still able to walk around the building if they are, and what it is that they require in terms of breaks, if they need breaks for their pregnancy. So I mentioned earlier that there's different categories of rights, the right to time off and the right to pay. And Selah and I will keep touching on this throughout the training because this is the place where things get the most confusing. So there are laws that protect your job and say, okay, if somebody's taking time off for their health, the employer has to give them that time. They have to return them to the same or a comparable position. And then there are benefit programs that allow somebody to get paid while they are taking time off from work. But those are separate programs with separate eligibility. So there will be times where somebody has the right to take time off and their job will be safe, but they might not be able to get paid by the state. And at the same time, there might be times when somebody can get paid by the state and continue receiving income, but it doesn't necessarily mean that their job will be safe. And workers who want to have an income, but also want to return to their job after they take time for family caregiving or their pregnancy or baby bonding, they need to have both of these things in mind so that they can make sure that their job is safe and that they're continuing to receive income throughout. So throughout the rest of this PowerPoint, we'll have these little icons of a lock for job protection and cash for wage replacement. And that will be a clue as to what this law or protection is about. So the first job protection law for during pregnancy that we want to talk about is called California Pregnancy Disability Leave. And what it does is it allows somebody to take off up to 4 months of leave when they are disabled by their pregnancy, childbirth, or a related health condition. And I want to note that some of the interpretations we have and the PowerPoint throughout are gendered, but gender does not matter when it comes to accessing these rights. So if somebody is not able to work because of their pregnancy, recovery from childbirth, or a related health condition, they can take time off from work up to a total of 4 months and know that their job will be safe during that time. This law also does not have any tenure requirement, so somebody can be brand new in their job and they can work part-time or only a few hours a week. But if they're an employee and they cannot work because of their pregnancy, they will qualify for pregnancy disability leave. This will also go into effect if, let's say, somebody asks for changes at work because of their pregnancy and their employer decides that they're not able to continue doing their job, or the employer is not able to accommodate them. So if because of somebody's health, they can't do their job, they will be covered by pregnancy disability leave. So for instance, if there's a patient whose job is to lift, 50-pound boxes, and that's all that she does, and her job really is just lifting 50-pound boxes all the time, and there's no alternate position that she can go into. If because of her pregnancy, she can't lift more than 30 pounds and she's not able to work, that would be enough to disable her so that she's covered under pregnancy disability leave, even though she'd be able to do my job sitting at a desk or somebody else's job that isn't quite as vigorous. So if someone cannot do their job because of their pregnancy, then this kicks into place and they'll be covered. It can be used broken up over time as well. So it can be used for prenatal appointments, or if somebody has serious morning sickness early in their pregnancy, and then that goes away and they're able to go back to work. And during the time that they take off, their employer has to continue any health benefits that they have. Importantly, pregnancy disability leave will start before somebody has their baby, and it also continues after. So while somebody's recovering from childbirth. So in an uncomplicated pregnancy where everything is going well and there are no health complications, healthcare providers can certify somebody as being disabled from working 4 weeks before their due date, and then for recovery 6 weeks after for a vaginal birth, or 8 weeks after for a C-section. But again, that can extend any amount of time up to 4 months, just depending on that person's health. So this is the time that someone can take off just because of their health, and it does continue after they have their baby. So there's also, of course, the important question of how does somebody get money during that time, because lots of folks can't afford to take unpaid time off. So we're fortunate that in California, we have a law called California State Disability Insurance. And what it does is it provides people with partial wage replacement when they are unable to work because of their health, including pregnancy and recovery from childbirth. So again, it's that same standard. Because of their health, are they able to do their job or can't they? And if they can't, then that is enough to qualify for state disability insurance. It's a program that workers pay into out of every paycheck. Unless you're a public employee, take a look at your pay stub and it probably says CASDI, and there's about a 1% deduction. And that's your money going into this fund so that if there's ever a time you cannot work because of your health, you can get part of your income. So that you can take time off without having to completely not have any money during that time. So it's not something that employers pay for or that comes from the state. It's folks' own money that they're investing into the fund, which I think is one of the reasons it's so important that everybody gets the support they need to access it, to get their own money back out. So for somebody who's pregnant, just like the pregnancy disability leave that we talked about earlier. They can start getting this disability insurance money before they have their baby, and then also after, while they are recovering from childbirth. And for people who have been recently laid off or terminated, they still might be able to receive this income if otherwise they'd be looking for work. So right now, most workers get 60% of their regular income through this fund, but starting in 2025, most workers will get 90% of their income. So that's something that we're really excited about, because hopefully it will mean that more people can afford to take the time off that they need to for their health. Some things to remember are that the first week of state disability insurance time is unpaid. So there's 1 week after somebody's disabled where they won't be able to get state disability insurance income. And importantly, immigration status and citizenship do not matter for getting this benefit. Like we talked about, it's folks' own money that they're paying into the fund. And that's the qualification. Have you been paying your money into the fund? And if you have, and you're not able to work because of your health, then you'll qualify. So the state does ask for social security numbers as a part of the application, but that's just to track how much money people are paying into the fund. And it's on their website saying that they do not care about immigration status, and that authorization to work in the United States is not a requirement to receive state disability insurance. And this benefit can last for up to 52 weeks. So if somebody has a long-term health condition that keeps them out of work, they can continue to get these benefits for up to 52 weeks total. So, of course, one of the important questions is, how should somebody apply for state disability insurance? And so one option is through the Employment Development Department's website. At their website, you can apply online, and this tends to be the quickest way to get your claim processed. But people can also apply using a paper application, which is something that we recommend for people who do not own a Social Security number. You can apply once your leave starts, up to 49 days retroactively. But if somebody has a good reason to be applying late, and it can even be like they didn't know that state disability insurance existed, in our experience, that's something that the EDD will accept as a good reason. People can still get their benefits even if they are applying late. But it's important to remember that a healthcare provider must certify somebody as disabled to get these benefits. Practically, once somebody applies, it will take some time for them to actually receive those benefits. But if there's a delay, generally, once they get that first payment, it will cover that time that they've been waiting. So if somebody doesn't receive their payment for a couple of weeks, it doesn't mean that they're going to lose a couple of weeks of pay. It would mean that once they get their benefits, they'll get those weeks that they've missed. So just to bring this back to the concepts that we were talking about, the right to take time off and the right to get paid during time off. We've been talking about pregnancy and childbirth. So for job protection, it's pregnancy disability leave that allows folks to know that their job will be safe when they're taking time off because of their pregnancy and recovering from childbirth. And it's state disability insurance that allows somebody to get paid during that time. And so here's a graphic that shows how this fits together. So this is a timeline of before somebody gives birth and after. So 4 weeks before, they will be able to take time off and have their job protected through pregnancy disability leave. And that will continue for 6 weeks after, again, if it's an uncomplicated pregnancy and birth, to recover. And then during that time, they'll be able to get income through state disability insurance. And so we'll come back to this graphic afterwards to add on how baby bonding fits in. So just to put this all together, we've got a sample person. It's Lena. She's pregnant and works as a cashier at a grocery store, and her physician puts her on bed rest at 34 weeks for her high-risk pregnancy. So the first question we want to look at is, can she get time off and pay? And the answer is yes, because she works at a grocery store. It probably has at least 5 employees. And that's the only qualification to make sure that she's able to take time off under pregnancy disability leave. And because she's not able to work because of her health, she'll also be able to get income through state disability insurance. So to touch on the important question, what is it that she actually needs to do to make sure that these things happen? We're breaking it down into 2 steps. So to make sure that her job is safe, she needs to be in contact with her employer. She needs to give her employer a note from her medical provider saying that she's disabled from working by her pregnancy and the expected start and end of her leave. If the date is unexpected, if she suddenly needs to go on to leave, she can give the note to her employer then. But if she has 30 days notice of when she'll need leave, she needs to give her employer that notice. And to get income during that time, she needs to apply for state disability insurance. And so that's through the EDD. And she'll also need to talk to her healthcare provider about filling out that certification. So she'll need to contact her employer, and then she'll also need to apply for benefits from the EDD to make sure that both her job is safe and that she's able to get income during that time. And I'll pass it to Selah to talk about baby bonding and caregiving.
Thanks, Katie. So yes, now moving on to after the patient has likely recovered from childbirth, they may be eligible for the California Family Rights Act. And this law provides 12 weeks of job protected leave per year to bond with a new child. And that includes adoptive and foster children. And this is available to both parents as long as both parents meet the eligibility requirements. The law is also available for folks who need to care for a family member, which includes a parent, a spouse, a domestic partner, child, grandparent, grandchild, sibling, parent-in-law, or very new law enacted just this year, a designated person, which is someone with a close relationship to the person with a serious, to the employee. All of those people with a serious health condition. So if you need time to take off work and care for a family member who has a serious health condition, this law provides time for that as well. Next slide, please. Thank you. This law also covers job protected leave for the purpose of your own serious health condition or needs arising from a military family member being deployed overseas. So again, with the example following someone who is pregnant and giving birth, for the person who does give birth, bonding leave, this California Family Rights Act time, does not start until after they have recovered from pregnancy and childbirth related disability, if the disability lasts less than 4 months. So just to reiterate what Katie said, pregnancy disability leave lasts for a maximum of 4 months, depending on the specific situation of the patient. But after the person has recovered from childbirth and if they are eligible for California Family Rights Act leave, they would take the 12 weeks to bond with a new baby after they have recovered. Also, just to clarify again what Katie said before. Yeah, so it's a maximum of 4 months, but it's not the situation where you get that amount of time necessarily. It's specific to your own, the patient's own particular circumstances. So it's not necessarily, it doesn't cover more if, for example, you don't take any time prior to taking leave before giving birth to the baby. And it can extend if there are reasons to extend it after for additional recovery time, both physical or if there are mental health conditions that require additional recovery time. But again, in an uncomplicated pregnancy, it will be 4 weeks prior to the due date and then 6 to 8 weeks after. And then after that period is when the California Family Rights Act would come into play for baby bonding purposes, for the purpose of the person who gives birth. And I will explain a little bit more below for parents who are not the birthing parent. So there are eligibility requirements for the California Family Rights Act. The employee must have been on the job for 1 year. The employer must have 5 or more employees, and the employee must have worked 1,250 hours in the prior year. We have a note here, and the reason why 5 or more employees is in red is because the law was extended to cover employers to smaller employers. And so it's important to be aware that some small employers may still not be aware that they are covered under this law. And it can help to, share our fact sheets with them, which we will share our website and where to find information about that towards later in the PowerPoint. So during the time that a person is taking California Family Rights Act time, although that's not a requirement, so you could apply for paid family leave regardless, but paid family leave, like Katie was speaking about, is the pay portion of this time of leave. Paid family leave, again, is administered by the Employment Development Department and provides partial wage replacement while someone is bonding with a newborn, adopted or foster child, caring for a seriously ill close family member, including all of the folks listed here, and for needs arising from a military family member being deployed overseas. For the purposes of bonding, paid family leave must be taken within the first year of the birth or placement of the child in the home. So again, paid family leave replaces 60% of income for most workers, and really exciting to announce that it will be increasing in 2025 to 90% for many workers. It provides up to 8 weeks of wage replacement or income, 8 weeks per year. So you'll notice it doesn't exactly match on to the 12 weeks of California Family Rights Act time, but it does provide 8 weeks per year. And again, citizenship and immigration status do not affect eligibility. It can be taken intermittently or all at once. And both parents can take paid family leave at the same time or at different times. How to apply for paid family leave is a similar process as STI. You apply through the Employment Development Department, either online or using a paper application. You can apply for this program up to 41 days retroactively, or even later if you have good cause. So again, for example, if you're not aware of the program, or there are other reasons that may have caused you to apply late, it's possible. And there is no certification required for baby bonding. So a medical provider does not need to provide anything for that. However, if someone is applying to take paid family leave for the purposes of caring for a seriously ill family member, they will need to provide certification from the care recipient's healthcare provider. So the person who is treating the person who is seriously ill will need to provide certification for that paid family leave application. So just to go over this again, we have a guide. We have a one-pager as well as a longer guide to provide information to undocumented workers applying to disability insurance and paid family leave. The first step would be to request a paper application, and then second, complete and submit the application, but leave the Social Security number field blank and attach a letter with proof of wages. The patient or person can expect a follow-up with the EDD that could come in the form of a phone call to provide additional information, and then 4, receive your benefits. So please know, we're saying it over and over again, you can absolutely apply to these programs as an undocumented worker. So I have an example here in Eddie. Eddie's granddaughter is born at 24 weeks and needs to spend time in the NICU. Eddie has been working full-time for his employer, which is a large construction company, as a welder for 12 years. Can he take paid leave? And feel free to, I guess, pop your questions in the chat. I'm realizing I won't be able to see. The answer is yes. So if his granddaughter has a serious health condition and requires care, he can take 12 weeks under the California Family Rights Act because he meets those eligibility requirements. He's worked for his employer for at least a year, at least 1,250 hours, and his employer has more than 5 employees. This, even though the child is newborn, this is not baby bonding. This is taking California Family Rights Act time for the purposes of caring for a seriously ill family member. So as the grandfather of the newborn who needs to spend time in the NICU, Eddie can take California Family Rights Act time to care for the baby. Because Eddie is caring for a seriously ill family member, sorry, Katie, he can access income through paid family leave, which will provide 8 weeks of wage replacement. What does Eddie need to do to keep his job safe and get paid? He will give his employer a note stating that he's taking his California Family Rights Act leave to care for his seriously ill grandchild. He'll also want to include the anticipated start and end of his leave, and his employer may require a medical certification. He will apply then for paid family leave from the EDD, and his granddaughter's healthcare provider will need to fill out the certification for the EDD. So returning now to our 2 key concepts, we've sort of filled out our chart here, going through the timeline. So for job protected time off of work, for pregnancy and childbirth, the law is pregnancy disability leave, which provides up to 4 months of leave for pregnancy-related disability. And for baby bonding or caregiving leave, the California Family Rights Act provides 12 weeks of job protected time for those purposes. Then moving to the right side, where we indicate with the cash, the wage replacement for pregnancy and childbirth, the patient would apply to state disability insurance, which can last up to 52 weeks total if the person remains disabled from working. However, again, pregnancy disability leave only covers a maximum of 4 months before needing to use other types of leave, such as the California Family Rights Act. And for baby bonding purposes and caregiving leave, paid family leave provides 8 weeks of wage replacement. Those are both administered through the EDD. And here is a slide that's sort of helpful just to see in terms of a timeline, starting at the beginning. Again, with this time, we'll start with the cash. State disability insurance up top. There is a 1-week waiting period. And again, this is for a CFRA eligible parent who gives birth and has an uncomplicated pregnancy. So this person will apply for state disability insurance during the time that they are disabled from working due to pregnancy and childbirth. They will have a 1 week waiting period, and then 9 weeks of 60% or 70% of wages, again, going up in 2025 to 90%. And then following that, they will apply for paid family leave. For the job protected portion on the bottom here, they will probably go out on leave 4 weeks prior to the due date, and then have 6 weeks to recover. And then after that, because again, they are eligible for CFRA and will want to take bonding time, they will take 12 weeks of California Family Rights Act time to bond with their new baby. This is a chart showing a similar thing, but for the parent who did not give birth. And so they would apply for paid family leave as soon as they would like to take it after the baby is born. And because they are CFRA eligible as well, they would take the 12 weeks to bond right away when the baby is born. Although you don't have to, you can take it within the first year of the child's birth, but in this situation, the parent would like to begin bonding right away. So they will not wait that additional 6 to 8 weeks because they themselves are not recovering from childbirth. They will start bonding right away after the baby is born. So we have another example here in Lena's baby is born, and then 6 weeks after her baby is born, her physician clears her to return to work. Can she take more leave with pay? And the answer is maybe. So if Lena's employer has 5 or more employees, if she's worked at least 1 year and she worked 1,250 hours in the year before her leave started, which is about 25 hours a week, she can take 12 more weeks under the California Family Rights Act. So it's important to remember those eligibility factors, which apply to CFRA, the California Family Rights Act, but not to pregnancy disability leave. Then because Lena is bonding with her baby, she can access income through paid family leave for 8 weeks. What should Lena do to keep her job safe and get paid? She should give her employer a note saying that she's taking California Family Rights Act leave and the expected start and end of her leave. Then she will apply for paid family leave. She may actually already have received a notice from the EDD asking if she wants to start paid family leave when her disability insurance payments ends. So that is great. Then she will just have the application already and be able to fill it out. So I want to move now again to lactation accommodations. So when the person returns to work, these are some of the guidelines that they should be aware of in terms of what's required at their workplace. Employers must have a written policy detailing their lactation policy. And so that can be actually a really great way to initiate a conversation about lactation accommodations at work, is just, ask to see, or you ask if there is a policy or where someone can find it, and then explain, I will be pumping breast milk when I return to work. The employer has to offer reasonable break time. So there's no specific set limit on the amount of time, but it has to be enough time. So for example, to get to the designated lactation space, be able to set up everything, and then adequate time to pump breast milk, take everything down, clean everything and put it away. So it's not a specific time, but it does need to be a reasonable amount of time, especially if there's like travel to and from the lactation space. These breaks do not need to be paid outside of normal meal and rest breaks. So if there are additional, there must be additional time given to take breaks to pump breast milk, but it does not need to be paid if it's outside of regular rest breaks. The employer also has to provide a place to pump that, really importantly, is not a bathroom. It has to be safe, clean, and free of hazardous materials, and it must contain a surface to place a breast pump, a place to sit, and access to electricity. And the space also has to offer refrigeration and running water nearby to be able to store milk and clean a breast pump. So I wanted to also talk about a few other laws that can be helpful to know about. The first is the San Francisco Family Friendly Workplace Ordinance. So workers in San Francisco can request accommodations to help with childcare or family caregiving. The employer must provide accommodations unless it would be very difficult for them to do so. And the eligibility requirements for this ordinance are that the employee must work at least 8 hours per week in San Francisco, have worked for the employer for at least 6 months, and the employer has 20 or more employees employed. I also wanted to give a little bit more information about bereavement leave, again, that Katie mentioned up top. This provides up to 5 days of unpaid job protected leave when a family member passes away. Family member is defined by the law as a spouse, domestic partner, child, parent, parent-in-law, sibling, grandparent, or grandchild. And the eligibility requirements for this law is that the employer has 5 or more employees, has worked for the employer for at least 30 days prior to taking the leave, and it must be taken within 3 months of the death of the family member. Some other rights and protections, which we can talk about a little bit more, you can access information on our website or contact us, include leave and accommodations for survivors of domestic violence, stalking, or sexual assault, leave and accommodations for COVID-19, including illness, exposure, vaccination, family care, and school closures, and leave and accommodations for enrolling in school and participating in school activities. So I know we have many questions in the Q&A, and I know we've been answering some. Katie, how would you like to? Oh, so we'd like to open up for questions, but just before we do that, I just want to point here to our website. It has a lot of different information, like some of the fact sheets that I mentioned, and we offer, that offer free legal advice and information in multiple languages. We also have a work and family helpline where we take calls, and people can call us and ask for individual one-on-one advice, and the number is listed here. How that works is that folks call us and leave a brief message, and someone on our team calls back within 1 to 2 business days to get more information and conduct an intake, and then we will provide one-to-one legal assistance. We also offer technical assistance on this line, so if you have questions that you want to ask of us on behalf of your patients, feel free to direct those questions to that line as well.
Great, and please feel free to keep typing questions in the Q&A. We've been trying to answer throughout in case we ran out of time, but because we have time, I'm gonna go through some of the ones that I think are probably broadly applicable that other folks might have questions about, and Selah, feel free to jump into with ones that you think are worth focusing on. So some folks asked about how the FMLA works with pregnancy disability leave and the California Family Rights Act. So the FMLA is a federal law that gives employees the right to take 12 weeks off from work if they need to for their own health condition, to bond with a child, or to take care of a seriously ill family member. So it's an important law to know for federal employees in California, because those federal employees in California are not covered by California protections. But the California Family Rights Act and pregnancy disability leave are both stronger than the FMLA, and they cover more people. And on top of that, they also run at the same time as the FMLA. So the FMLA is not going to give somebody in California additional time off from work, because it will have run at the same time as their pregnancy leave or at the same time as their California Family Rights Act leave. The useful, important thing about the California leave laws is that we have those as 2 separate protections: pregnancy disability time, and then baby bonding time and family care time. And the reason that it's so good that those are separate is that's what allows people to take time off for their pregnancy without having to eat into that baby bonding time. So instead of having 12 weeks total, in California, somebody who gives birth, they have those 4 weeks before in an uncomplicated pregnancy for their health, 6 weeks after to recover with an uncomplicated delivery. And then it's only after they've already been out for those 10 weeks that their 12 weeks of baby bonding would start. So in a typical uncomplicated pregnancy, the person who has a child would actually be able to take 22 weeks off instead of 12. So that's why we want to focus on pregnancy disability leave and the California Family Rights Act. Let's see, there were also questions about a parent who isn't the one who gives birth. So if they're taking time off for baby bonding, that time they'd start it once the baby is born. But if their partner who's pregnant is having like a very difficult time and that person's healthcare provider says, okay, the pregnant parent, they need support, they need somebody to be providing them with care. If there's that provider is willing to write a certification saying, this person needs their partner to provide care, then somebody could take time off to provide care for that person beforehand. But otherwise, the time is just tied to the birth of the child. So other questions that we haven't answered yet is somebody asked about if their job ended in 2022, if they could still qualify for paid family leave. So to qualify for paid family leave, somebody needs to either be taking time off from work, or they would be in the labor market, like looking for work, except for the fact that they're bonding with a child or taking care of a seriously ill family member. So the time period that the EDD will look at to see if somebody can get benefits is not the income that you're making in the current quarter of the year or the income from the quarter of the year before that, but then the 4 quarters of the year leading up to that, which I know is like a little complicated, but it builds in a buffer. So if somebody had a job in the recent past where they were getting pretty good income, then that would be the time that their wage replacement would be based on. But we're also happy to answer one-on-one questions for folks who want to call our helpline, and we can provide even more specific advice. Somebody else asked about requesting teleworking with to help with childcare. So in San Francisco, we do now have a law where people working in the city can ask for changes to their work to help with family care, including parenting. So in San Francisco, somebody could make that request and their employer would be required to let them have a change to their work as long as it's not too much of a hardship on the employer. But across the rest of the state, unfortunately, there's not a clear, strong protection that allows people to get accommodations for the purpose of caring for their children, unless maybe they have a serious health condition. So that's kind of a gap in the law, and I think a place that it needs to move forward so that people can get the changes at work that they need so they can keep doing their job and they can take care of their family. Selah, were there any questions that you wanted to focus on or highlight for folks?
Yeah, I have a great question here. Someone asks about the enforcement mechanisms and how workers can make a claim and what types of penalties there are, if any. So this is a great question I wanted to highlight just because there are agencies that enforce these laws, and we are here as advocates for certain situations where these laws may be violated. We can also help folks if they have questions about speaking to their employer about some of these rights or how to ask their employer. And so we will drop the number, or it's here on the screen, the number for our one-to-one helpline. Please do feel free to direct people who might have questions about that or need specific help to our helpline, and we can further assist based on their own specific situation.
Great. I'm seeing some questions come up too about undocumented workers. So in our guide, we have step-by-step what papers folks might want to send in, like pay stubs and W-2s to help prove that they've been earning money. In some circumstances, they can write the letters to the EDD and explain the social security number that they've been using, and the EDD can use that to match the money that they've been paying in with the person who's been paying it in. But there are also times where maybe the employer's not paying that person's money into the fund. And in that case, there's still the opportunity for somebody to prove like, look, I was earning wages and, it's not my fault that the money wasn't paid in. Like, this is the money that I earned, and to prove to the EDD the income that they earned. And in that undocumented workers guide, we have steps about what information somebody can provide to show, look, I was earning income, I am an employee. And in that case, even if money wasn't taken from their paychecks to go into the account, it is still possible for them to qualify to get paid family leave or state disability insurance.
I just want to add here too that there are some situations where people should have been paying into the fund, but they are wrongly misclassified as independent contractors. And so we also have a guide that helps people determine if they were incorrectly misclassified, and to help also allow them to apply for SDI and PFL.
I'm seeing some other questions about paid family leave and taking it for caregiving and for bonding. So we have paid family leave, which is the way that you get income from the state if you're taking time off to caregive or to bond. And someone can qualify for 8 weeks of that total within a year. And that's 8 weeks for whatever reason. So even if there's multiple reasons, it's still only a total of 8 weeks. And it can be taken all at once, but it can also be broken up. And we're working on a guide that explains how folks can report to the EDD that, like, I'm working part-time and I want benefits part-time, or, I'm only taking an afternoon off or two a week. But separately, you also have to keep in mind the job protection half of it, the California Family Rights Act, which gives people the right to take 12 weeks off with their job protected. And similarly, it's 12 weeks in a year. So even if there's multiple reasons that somebody is taking time off, it's only 12 weeks total. So if somebody took time off to take care of like their sick parent earlier on, and they used 6 weeks, if they have a baby later in the year and they want to take time to bond, they're only going to have their other 6 weeks left to do that. And that time can be broken up as well and used intermittently if it's medically necessary. But if it's being used to bond with a baby, employers have more control of how that person breaks up their time, if they're trying to break it up into segments that are smaller than 2 weeks. All right, and we're at 1:15. Selah, was there any last burning question you wanted to answer, or should we wrap up and give follow-up instructions?
Yeah, there are some additional questions. I would just encourage, again, people who have individual questions or technical assistance questions to call our helpline. Also, when we share out through email the slides as well as the presentation recording, we'll provide information to contact us if you have additional questions. Thank you all again for your patience and your understanding with our technical issues, and for joining us today.
Thanks. And we will be following up about a Spanish language training as well. So feel free to reach out, like Selah said, and thanks so much for joining us today.